Good morning, everybody. Today, as you all know, we have taken a very specific topic. We are not discussing too many statutory provisions or complicated provisions pertaining to the exemptions, etc. We'll take up the problems caused due to the new registration regime. So ever since 2021, when this registrations, permanent registration of 12A and 80G were done away with, and a new regime came. So organizations have been facing problem, and many mistakes have been occurred in past. The provisions of provisional registration, provisions of registration under 1023C, 12A, all have been created confusion, and a lot of mistakes have happened. And very recently, CBDT issued a circular giving relief to organizations who failed to get their registration or by mistake got a different registration, a provisional registration, organizations who failed to convert their registration into a permanent registration. So we will be discussing specifically that circular and the issues arising out of it, and try to give practical tips of how to address various situations and doubts arising out of it, some from our practical experience after the circular was issued. So today we have divided this into two parts. In two sessions, we will take up various nuances of this circular. I think with this context, I invite Tarun to take forward the first session.
Thank you, sir. Good morning, everyone. Namaskar. So I'll just share my PPT. So I hope my screen is visible. All right. So friends, as Manoj sir has suggested, our today's discussion is about the recent changes in the registration and approval provisions related to NGOs, and what are the issues being addressed by the CBDT circular number 6 of 23 dated 24 May 23. So friends, it is very important to understand that registration is the first and foremost requirement for an NGO to enter into the exemption regime. There are special provisions for the taxation of NGOs under the Income Tax Act. We have a regime called Section 11 to 13, and there is a approval scheme under Section 1023C. So it is the first requirement once an NGO wants to opt for either of these regimes. Either it has to get approval under Section 1023C or get itself registered under Section 12A. So registration is the first condition, but it is not the only condition. There are other conditions as well, and there are other compliances as well, which it needs to ensure. There is a requirement to maintain books of accounts. There is requirement to get the books of accounts audited. There is requirement to file the ITR. There are computation provisions. There are many ifs and buts which the NGO need to comply with. But it only has to done all these compliances if it is registered. If it is not registered, then the taxation will be in a separate manner. So as sir suggested, we have divided our today's session into two parts. First of all, we will discuss in the part one what all the recent changes being introduced by the Finance Act 23 in the provisions related to the registration and approval scheme. What are all these changes? And in the part two, we will discuss about the impact of the recent circular, what all clarifications it gave, what all relaxations it gave, and what are issues which still remain unaddressed even after this clarification circular. So you need to appreciate that this is the first requirement, but in the past we have seen the amendments which have made the registration procedure so complex, and to clarify all those provisions they have to bring in the circulars, and even after the circulars there are so many issues which are unaddressed. There are so many challenges being faced by the charitable trust. So collectively today we will try to find answer to all those issues, all those controversies, that how we can take care of all these while complying with the registration provisions. So I start with the part 1 and part 2 will be taken up by the Suresh sir. So in the part 1, we will be discussing about the amendments by the Finance Act 23. So before jumping into the amendments, I'll just like to give you the overview of the registration scheme of the NGOs under the Income Tax Act. So as I suggested you, there are two main schemes. First one is under section 11 to 13 and the other one is section 1023C. So under section 11 to 13, under section 12, where there is a conditions to get the NGO registered, there is a condition to get to maintain the books of accounts, requirement to get audit and filing of ITR. So the first condition is to get the NGO registered. And similar, there is a requirement under section 1023C to get NGO approval. And there is a simultaneous requirement under section 80G. If NGO is approved under section 80G, it can pass on the benefit of donation to the donors. And in the Finance Act 2020, there were amendments were introduced. There was a complete overhaul change in the registration mechanism. And later on, these amendments were deferred to the 1st of April 21. So this new scheme of registration under section 12AB was effective from the 1st of April 21. So under this scheme, there is a complete electronic procedure for the NGOs to get the registration or approval. So if your NGO was registered or approved prior to 1st of April 21, there was a one-time requirement to get itself re-registered, and the registration will be granted only for a period of 5 years. And there is no concept of perpetuity of registration. You need to get your registration renewed even after every 5 years. Further, they introduced a concept of provisional registration, which was emphasized for a new charitable trust. If anyone is applying for the first time, it has to apply for the provisional registration. Then this provisional registration is required to be converted into the regular registration. So this is an overview of the registration scheme of the NGOs. So now we will discuss about the amendments by the Finance Act 23. The first amendment is registration or approval categorized based on the commencement of activities. This is very, very important thing which we need to understand. So what was the position before the amendment by the Finance Act 23? That if a charitable organization is applying for the first time, it needs to apply for the provisional registration in Form 10A. Then this provisional registration has to be converted into the regular registration within the 6 months of commencement of activity. And that application for the conversion has to be filed in Form 10AB. So what was the practical challenge here? That an NGO has to apply for the two registrations simultaneously, because it will not be possible that if once an NGO is registered as a provisional registered organization and it will remain without commencing its activities for a period of 3 years. So practically both the applications were required to be applied simultaneously. So what change Finance Act 23 bring in? So it says that with effect from 1st of October 23, if an NGO has not commenced its activity, then it has to apply for the provisional registration. Otherwise, it need not to apply for the provisional registration. So therefore, only those trusts or institutions which have not commenced their activities, they have to apply for the provisional registration. And if any NGO has already commenced its activity, then it need not to apply for the provisional registration first. It can directly apply for the regular registration. So what is the condition for it? The first condition is it should have already commenced its activities. The second condition is its income should have never been excluded from the total income because of the approval under section 1023C or the registration under section 12A. So if any time in the past you were registered and your registration was surrendered or cancelled by any reason, so you cannot apply for the registration because your income would have been excluded in the past. So just 4 or 5 days back, they have introduced the income tax 11th amendment rules in the Form 10A and Form 10AB. They have made an amendment. So under the declaration in the Form 10A, now the NGO has to declare that whether it has commenced its activities or not. If the activities have not been commenced, then it can apply for the provisional registration in Form 10A. And similarly, if the activities have been commenced, it has to give the declaration in Form 10AB that my activities have been commenced and I am applying directly for the regular registration. This is very important because you need to declare yourself that my activities are commenced or not. Because if you give a false declaration, your registration can be cancelled in the future, because giving a false declaration or a false information in the registration application will amount to the specified violation which can result into the cancellation of registration. And not only the NGO has to declare, recently they have introduced the updated form 10B and 10BB audit report. Even in the audit report, they have given a clause wherein the auditor need to certify that whether the activities of the NGO has been commenced or not. So based on that auditor declaration, whether the NGO has converted its provisional registration into the regular registration within the prescribed time limits. So both NGOs and auditors have been casted with the responsibility to declare whether the activities are commenced or not. But the interesting thing is, they are asking from the NGO as well as auditor that whether the activities are commenced or not. But in the law, nowhere it has been defined what shall mean by the commencement of activity. So we need to understand what exactly do we mean by the commencement of activities. So I'll invite Manoj sir for his remarks, sir, what we shall consider as commencement of activity.
I understand, Tarunji have rightly mentioned, to the emphasis is given on the term commencement of activities, but this term has not been defined. And therefore, it may be the date when the NGO has set up, or it may be the date when the NGO has opened the bank account, or it may be the date when the NGO has started raising of funds, or it may be the date when the NGO has started some amount towards application. Okay. So we understand from the holistic point of view, when the NGO started spending some money or applying some money, and then only the date of commencement start. So once the organization is set up, it should not be the date of starting of charitable activity, and it should be when the actual amount has been spent, maybe a small amount, on some program or on some activity. I think Manoj can add to this.
Yeah, no. Just to explain what Sureshji is trying to say, that the word activity has been used instead of charitable activity, which creates a doubt in the mind that activity can be anything. It need not be towards application of income. But what we understand and we recommend is that the commencement of activity should be treated in common parlance, and for the sake of simplicity and not getting into any controversy, our understanding and recommendation is that when the first rupee is used towards advancement of objects, so with the date the first rupee is used or applied towards charitable purposes, that is the date we should consider as a commencement of activities. Otherwise, there could be so many interpretations. Even after registration, you apply for PAN card, that is an activity. You open a bank account, that is an activity. So the activity related with application of income, that first instance should be treated as a commencement of activity.
So as sir have said that commencement of activity will be the spending of money towards the objects of an organization. So it is very important because for the two reasons, because your application category will be dependent on the fact whether you have commenced or your activity or not. Second important thing is auditor need to certify in form 10B or 10BB if they are signing an audit report for the provisional registered organization, that whether such organization had commenced its activity or not. And based on that factor, whether within the prescribed time limit that conversion application was made or not. So that's why it is very important to determine the right time when the activities were commenced. So sir, as you said that what shall we mean by the commencement of activity, and we said that there are strict time limits to convert the provisional registration into the regular registration. So many times we see, because that's how the scheme of registration is introduced by the Finance Act 2020, that even if organization has already commenced its activities and it's applying for the first time, it need to apply for the provisional registration first, and then it need to convert its provisional registration into the regular registration. The provisional registration is otherwise for a period of 3 years, with the caveat that it needs to be converted into the regular registration within the 6 months of commencement of activities. And if the organization has already applied for the provisional registration before it has commenced its activities, now what shall be the due date for conversion in such cases?
No, this is a major controversy, because a large number of organizations have failed to apply within 6 months from the date of receipt of the provisional registration certificate. So then the issue arises, can they argue that they were existing organization at the date of application and this fact was disclosed to the department? Therefore, since the certificate is valid for 3 years, could they be allowed to continue the registration for 3 years, and in the last 6 months, prior to the commencement of last 6 months, they would be entitled. But on a conjunct reading of the intent of the statute, and even if you read the intent of the finance minister when this provision was enacted, and the 2003 amendment where now this anomaly has been removed from the act, because you no longer can apply for provisional registration if you are an existing organization. In this background, we understand that the intent of the act, and there is no clear in the provision in the act to suggest that a provisional registration could possibly provide exemptions for complete 3 years, because provisional registration is a prima facie registration without verification of any document antecedents or the genuineness of the organization. So therefore, to our understanding, it should be the date from which the certificate was received, the organization should have applied. The organizations who have failed and they don't have any option, they may pursue the route of applying for condonation to the CIT, make an application with condonation, and if it rejects, they may agitate before the court of law. But that is a controversial issue. We don't know how the court will interpret it. But our understanding is that we should take it as 6 months from the date of issue of certificate, provisional certificate.
Sir, now they have introduced the 2 categories. As you said, the amendment by the Finance Act 23 has removed this anomaly that if you have already commenced its activities, you can directly apply for the regular registration. But while the categorizing this, they have put an additional condition into it that if you are applying for directly for the regular registration, your income should never have been excluded from the total income because of your approval under Section 1023C or your registration under Section 1112. Now, if the organization was registered in any time in the past, even in the 10 years back, and if registration was cancelled or it was surrendered for any reason, so whether such organization will able to claim the benefit of registration or approval in the future, sir, because this amendment is effective from the 1st of October 23.
So prior to October 23, if they apply, there is a possibility. Otherwise, the language of the act is such that any organization at any time in the past, if it had claimed exemption under Section 11 or 1023C, such organizations have been made ineligible for future registration. So maybe we may see an amendment to this act in times to come. But as the statute stands today, it will not be possible. So it should be done prior to 1st October. If you organize
just to add here, Manoj,
yes,
this provision is also going to face through a very challenge on the issue of ATG certificate, because normally some of the NGOs were not applying ATG simultaneously with the 12 baby. They were waiting for 1 year or 2 years and then they were applying for ATG. Now, if they are not applying simultaneously and after 1 year they want to go for ATG, and by that time they have claimed exemption under Section 12 baby, then their ATG entitlement will gone, because at the time of making ATG, they have to give a declaration that their income will never been exempt under Section 1023C or 1112. So after October, we have to apply both together with. We should not wait for ATG to apply after 1 year or 2 years.
That is a very insightful observation, because the act even for ATG stands, but in the light of the fact that 12-way registration is a precondition, and the simultaneous registration preconditions means that ATG can be either simultaneous or the ATG should be preceded by a 12-way registration. This part is again quite a complex. Maybe the language of the section should be rationalized. I think for the purposes of this seminar, we should leave it there, and we should recommend that to the extent possible, it should be done simultaneously. Not that if it is done at a later date, the organizations will lose a right, but it may be subject to litigation, or if the department takes a strict interpretation the way Sureshji is suggesting.
So it has sort of created a impossibility or a deadlock situation that anytime in the future they'll not be able to go into the exemption regimes. So it is better to apply before the 1st of October 23 to avail of the benefits of registration or approval. So going to the next amendment, that is giving incomplete, false or inaccurate information in the registration application. So as of today, there are two application forms, that is Form 10A and Form 10AB. If you are applying for the re-registration or the provisional registration, you have to apply in Form 10A. And if you are applying for the regular registration directly or for the conversion of provisional registration to the regular registration, you have to file an application in Form 10AB. So what the law says, so there are cancellation provisions under the Act which says that the application or the registration, I would say registration, can be cancelled by the Principal Commissioner of Income Tax or the Commissioner of Income Tax if it has noticed an occurrence of any specified violation, and there is a list of specified violations under which the registration can be cancelled. So earlier there was a mention in the rule that registration can be cancelled if there is incomplete or false or inaccurate information in the registration application, but there was no explicit provision in the law itself which says that the registration can be cancelled. So now they have inserted a clause G in the explanation to section 12AB4, which says that specified violation shall also include the cases where the application referred to in section 12A1 AC is not complete or it contains false or inaccurate information. So if you are filing an application, you should ensure that every detail you are mentioning in the application should be accurate, it should be correct to the best of your knowledge, because there are multiple details being asked in the application for the registration, and the cancellation provisions are very harsh. If your registration is cancelled, as we just said, that you will not be able to claim the exemption in the future itself. So although there are registration cancellation provisions, but these provisions should be used very consciously by the Principal Commissioner and Commissioner of Income Tax, because the implications will be very harsh. Now, another amendment by the Finance Act 23, that is withdrawal of retrospective benefit of exemption under section 11 and 12. So under section 11 and 12 exemption regimes, there was a proviso to section 12A2, which says that the exemption under section 11 and 12 shall be available for the assessment year for which the assessment proceedings are pending before the assessing officer as on the date of registration, and assessing officer shall not take any action even for the reopening of any assessment for any assessment year preceding the first assessment year for which the registration applies, merely for the reason that such trust or institution has not obtained the registrations. So it was a very beneficial provision which provides a relief to the organization that their exemption will not be withdrawn merely because of non-registrations. Now the Finance Act 23 has omitted this proviso, and you will not be able to claim the benefit for the previous years. Now it has posed many challenges and many hardships for the NGOs. Sir, how situation will be tackled after the deletion of this proviso?
No. This proviso has taken away in 2014. This was for a brief period of 8 or 9 years. This relief was given to charitable and religious institutions to allow existing institutions to come for registration and claim exemptions without fearing about reopening of their immediately preceding year's assessment, because this provision said that whatever the taxes have been paid, they cannot be refunded, but all open assessment will be assessed giving effect of section 11. So now this provision is not there. So now it is as simple as that. You organization will be treated as a non-exempt organization till the year from which the exemptions are available, and the organizations have to pay taxes, and the organizations who have not paid taxes properly prior to 12A registration, they should prepare to pay taxes. Otherwise, it will become very difficult for large organizations to avail 12A registration. So that window of relief to existing organizations with income which are taxable is no longer there. So this is going to create a lot of hardship, and major relief has been withdrawn. We don't see that there is any other way the past years tax exemptions could be claimed. Sureshji?
Just to add what Manoj has said, for the issue is from the NGO perspective, and now the second litigation issue may also arise because this provision has been related without any saving clause. That what will happen to the already certificate being issued before 31st March 23, but for which the assessments are pending. So whether for those cases, this benefit shall be available or not. Though technically and from a reasonable point of view, those registrations which have been already been issued before 31st March 23, they were under the regime of this provision previous year benefits. But because of the withdrawal deletion of this provision altogether and without any saving clause, this may also create some litigation from the time of assessment when we are going to claim this previous year benefit.
But Sureshji, though it is still early days, we don't know what will happen. But what we believe is that all those certificates which were issued prior to Finance Act 2023 and those assessments which were open and were already subject to this provision prior to the enactment of Finance Act. So since they were already subject to that provision, there cannot be an arbitrary retrospective withdrawal. That is what we are interpreting. So the organization may believe that they probably can claim the exemptions, but no more future registration after 1st April 2023. Though, of course, it is prone to interpretation, which time only will tell.
Sir, and interestingly, the intent behind introducing the deletion of this proviso was that organizations need to apply for the registration before the commencement of activity, but still they have option to apply directly after the commencement of activities. So that will be a challenge for those organizations who are applying at a later date after the commencement of activities.
Yes.
So next, very important amendment. What will be the consequences of non-filing of application for re-registration or renewal of registration? As we discussed in the initial slides, in the overview of the registration schemes, as we told you that now there is no concept of the perpetuity of registration, and the registration will be valid for a limited period of 3 years or 5 years. And there are strict time limits to convert the provisional registration to the regular registration, and even for the re-registration after every 5 years. So there is a special provision under section 115 TD which levies accreted tax in certain circumstances. So as I told you, there are strict time limits for the existing registered organization which were need to register for the one time for the 5 years period. And once they are registered for the 5 years, that registration needs to be renewed after every 5 years. And if an organization is registered for the provisional registration, it needs to convert its provisional registration into the regular registration. So what amendment Finance Act 23 brought in? It says that trust or institution which are registered under section 12AB or approved under section 1023C, they shall be deemed to have been converted into any form not eligible for registration if it fails to make an application for the re-registration or re-approval, it fails to make an application to convert provisional registration to the regular registration, or it fails to get its registration renewed. In such cases, the conversion date shall mean that last date for making an application for registration or approval expires. So once you fail to apply within the prescribed time limits, you will be considered as you have converted it to any form which is not eligible for registration, and it will invite the levy of accreted tax under section 115 TD, which is when your net worth is taxable at the maximum marginal rate. This is again a very harsh provision, because as we told initially that you need to convert your registration into the regular registration within 6 months of commencement of activities, and many people have missed those deadlines because either they were not aware that what shall constitute the commencement of activity, or they were not aware of the provisions, or there were technical glitches at the portal as well. There could be any reason for which they missed the deadline for the conversion, or some people missed the deadline for re-registration as well. So all those cases, they have now levied the accreted tax because they have been deemed to be converted into a non-charitable organization. Now, what will be the implications in such cases? Now, since there was requirement to apply for the re-registration for the Section 12A trust, Section 1023C approval, and Section 80G, and the time limit was 3 months when this provision came into force. So it was initially required to be applied by the 30th of June 21, but the deadline was extended multiple times, and the last time it was extended deadline was 25th of November 22. So if an organization has failed to apply by 25th of November 22, then such organization shall be subject to accreted tax. So if your organization was registered before 1st of April 21 and you have not applied for the re-registration by the 25th of November 22, then your organization will be subject to accreted tax. Similarly, there are timelines to convert your provisional registration into the regular registration that has to be converted into the within the 6 months, which is by filing the Form 10AB. And the deadline to Form 10AB for the cases was extended to the 30th of September 22. And if no application is filed by the 30th of September 22, then you also will be subject to accreted tax. Although some reliefs have been extended by the circulars in such cases, which will be discussed in the part 2 of today's session. So, but some issues which are still remain unaddressed by those circulars, we are discussing only to that extent, because the reliefs which have already been passed on by the circulars will be taken up in the part 2. So, sir, the section 115 TD provides that if trust fails to apply for the re-registration or reapproval, it will be deemed that it has been converted into any form which is not eligible for the registration. Sir, what if someone was registered or approved? Now it has shifted to the non-approval category because its receipts are below 5 crores. Whether in such cases, since it has failed to apply for the re-registration, it will be deemed that it has been converted into non-exempt category, because it still continues to be a charitable entity, but in the non-approval category. Whether such conversion will apply, invite the provisions of 115 TD of the accreted tax.
Yes, Tarun, you are probably referring to educational and medical institutions, which earlier were subject to 1 crore revenue. Now they are exempt up to 5 crores. So many 12A registered organizations stopped taking benefit of 12A because they were eligible under 1023C, 3AC and AD directly without any approval. But now the issue is that even if for the last few years you are not availing the benefit of 12A or 1023C and you are directly claiming the benefit under section where no approval is required, still once the registration certificate is valid, 100 TD in our opinion will apply. So therefore, it is recommended that organizations whose receipts are less than 5 crore, they should also get their 12A registration renewed or 1023C registration approval. And they may not avail the benefit. They may not avail the exemptions under Section 11 while filing the return. They may continue to take benefit as an organization below 5 crore. But if 115 TD will apply, it will not be exempted only because they are otherwise exempt.
Sir, another question, sir. If an existing organization which was registered under Section 12A prior to 1st of April 21 and it was required to re-register itself for the period of 5 years, but by mistake, many people, since the law was new or out of ignorance, many people applied for the provisional registration. And even this provisional registration was regularized within the prescribed time limits of 6 months and converted into the regular registration. Whether 115 TD shall apply, because they have not applied for the re-registration. They have applied for the provisional registration and then such provisional registration was converted to the regular registration, which was otherwise they were required to apply for the re-registration.
Here there are two possible circumstances where they by mistake applied for provisional registration and that provisional registration has not yet been regularized. The other is that because when they applied for provisional registration, it was a mistake both at the end of the department as well as at the end of the applicant. So in these cases, let us divide it into two parts. All those cases where the provisional registration has been converted into a 5-year registration, because a 5-year registration is a registration subject to inquiry and due diligence by the department. So if through due diligence, a department has issued a 5-year certificate, I think that certificate should stand good, and no requirement is there. As a matter of abundant caution, they may write a letter to the CIT exemption explaining the situation and seeking a clarification whether they are required to do a fresh registration under the extended time limit, but they did not require to do anything. But we will advise them that as a precautionary measure, they should write and seek clarification. So in case of any confusion in future, that protection will be there. But all those organizations which have provisional registration, whether within 6 months or whether the 6 months has elapsed, they should surrender their provisional registration and should apply for this 5-year registration.
Just to add here, Manoj, because the intent of 115 TD was to avoid a situation where the organization has done away from the income tax regime and just by non-filing. So in such cases where the 5-year registration has already been granted and the organization is very well within the department record as a registered organization, so I think as per the intent also, what Manoj has said, there is no need for surrendering this 5-year registration applying again in clause 1. But better to give a information to the CIT exemption.
So because the memorandum, as Suresh sir has said, the memorandum explaining the provisions of Finance Bill 23 says that the intent to bring this provision was many people, while they were claiming exemption for so many years, and suddenly they convert themselves into the non-charitable entities by opting out of the exemption regimes. But if the organization continues to be to the exemption regimes, it was out of mistake or out of ignorance, it has been converted into the provisional registration, and then provisional registration was converted into the regular registration, which was subject to the inquiries by the department. So ideally, it is a fit case where the 115 TD shall not get attracted. So now we will be moving to the next part, where since the Finance Act 23 has brought in many amendments related to 115 TD, and there were many portal related issues, there were many other issues which were addressed by that circular. So now I'm handing over the stage to Suresh sir for taking up the next part, and we will take up all your queries towards the end of the session.
I will share my presentation.
Yes, sure.
The slide is visible?
Sir, it is visible.
Okay. So now the circular number 6 on 24/5/23 has really brought a very, very great amount of relief for most of the NGOs who have failed to submit their applications within the timeline. And the intent of the circular was to get the relief because of the 115 DD provisions, which came quite after when the default has already been committed by the NGO by non-submission of timely application. And that time 115 DD was not there. So by their subsequent act, they have been penalized under 115 DD, and to also to give a relief to the NGOs, this circular number 6 has been introduced to take away or to give relief from the implication of 115 TD, which Tarunji has already explained to you, that as per the 115 TD, if we have failed to apply for re-registration and reapproval within the timeline, then such cases shall be under section 115 TD, and that means we have to pay aggregated tax. And similarly, if we fail to convert our provisional registration to a regular registration by applying again in form time AB, then also such non-applications shall result into a 115 TD liability in such cases. Now, what the circular provides, what the circular gives you the relaxation. The circular gives you the relaxation Firstly, for those organizations which were existing organizations as on 31st March 21 with 12A and ATG approvals. And those organizations have been categorized in this relaxation form in circular in two forms. In one cases, they have not made any application so far for re-registration for 5 years or re-approval for 5 years. They have not made any application. And second, they have covered that as because they have filled that timeline to submit their application for 5 years, and this circular has came only in the month of May 23. So, and by then some of the NGOs might have applied for a provisional registration to continue with the exemption regime. So they have covered in both the cases what still happen to those organizations, whether they are covered under the circular or not, and what shall be the process. In the first category where no application has been made so far, in those cases, the circular says they have to just make a fresh application in form number 10A, one for the 10AB and 1023C as the case may be, and another 10A application for the approval under section 10G. So we have, if the no application has been made, you have to simply file 10A for the registration and approval, and again 10A for ATG approval. The registration shall be granted for 5 years without any verification, and in such cases, no exit test shall be levied. So for the NGOs which have not applied and we have not gone for the provisional registrations as of now, for them the process is very, very simple. Now for the NGOs who have already applied for a provisional registration because of the missing of the time, missing the deadline to submit the application in time. In those cases, the circular says if they are the provisional registrations which have been missing the deadline of 25/11/22 and they have obtained provisional registration, then they should surrender the provisional registration and approval, and they have to submit the fresh application till 30th September, and they have to apply for re-registration to both under 12AB and 1023C and ATG. So here again, if any NGO which were eligible for a 5-year registration as on 31st March 21, and they have applied for provisional registration only because of the missing the timeline, they are again eligible for applying again by surrendering their provisional registration and approval, and they have to make application again in form number 10A, both for 12AB or 1023C or for ATG. And in such cases, again, the 5-year registration shall be granted and there shall be no exit tax. Now the issue arises as because clause 8 of the circular provides that it is clarified that where the trust have missed the deadline of 25/11/22, then they should surrender the provisional registration and apply for a new registration. And while mentioning the deadline of 25/11/22, they have mentioned the clause para 1A, and the para 1A of the circular provides that the due date of filing form number 10A in case has been extended first to 31st August 21, then extended to 25th June 21, then extended to 31st March 2022, and then extended to 25/11/22. So now the issue is, by providing the date of 25/11/22 in clause 8, whether this recognizing benefit is available only to NGOs who have obtained provisional registration after 25/11/22, or whether all the NGOs who have missed any of the deadline, that means 25/6/20, that means of August 21, or of that March 22, or of 25/11/22, any of this category, they can apply, they can surrender their provisional registration, and they can opt for then they can submit form number 10A for the 5-year registration.
Sureshji, as we have been debating, our understanding is that this circular benefit will be available to all organizations who have missed their deadlines at various dates. So it could not have been. It seems that this particular that line of deadline on 25/11 is a kind of a residual clause, not in contradiction to the earlier clauses. So the idea is that whoever has missed registration, whoever was eligible for registration, but for some reason during this period has missed, they should all be eligible to reapply. In fact, in some cases, we have seen that the organizations belonging to the category prior to November 25 have also already received registration. But sometimes the legal understanding is sometimes is challenged by the utility in the portal. So right now, as we understand that organizations are allowing, so if an organization is having registration under provisional registration, it should surrender and apply for the new registration. So our understanding is that it should be available to everybody, that is consistent with the intent for which this circular has been brought. Sureshji, this
yeah, you are very right, Manoj, because the intent of the circular is to take away to take away from the hardship to the NGO of the NGO from this 115 TD. So only provisional registration after 25/11/22 shall be eligible for this circular, and not the provisional registration received before 25/11/22. I see no reason for such intent. And in the past and in the last 7-8 days, we have also received the regular registration in such cases as well. So we see all the provisional registration which have been received, though they were eligible for 5-year registration, those organizations can surrender and they can get a 5-year registration. Now, Manoj's second issue arises if an existing registered organization under Section 12A has mistakenly obtained provisional registration by selecting the wrong code. Because they should have been selected the code 1, they have selected code 6 for the provisional registration. And so what they will do? They will again they will surrender and they will apply again, and what shall be the option for them?
No, that is what we have been seeing, and we have already experienced also in some cases which we applied after the circular. All such organizations should surrender the provisional registration which they have. Unless that provisional registration has been converted into a 5-year registration, we discussed a little earlier, and they should apply because in any case it was a mistake, and they squarely fall under the purpose and the provisions of this circular because they were eligible, and it was a mistake. And for some reason, if the in future, if this utility is blocking them and they are unable to surrender, then they should file an 154 petition because they were eligible under for 5-year registration only by mistake. It is a prima facie mistake at both the end, and they must have uploaded the old certificate also. So therefore, our understanding is that right now the utility is allowing surrender of such certificate in such cases who have taken mistakenly registration, provisional registration, and they should go for, under no circumstances, they should forego this opportunity of availing, and at least they should apply. If they face any problem, they should, in writing, they should engage with the CIT exemption so that their right remains intact. Otherwise, once 1st October comes, they will be subjected to 115 TD. So therefore, it is very important that they apply and get it under this 5-year registration.
Right, Manoj. Now, another issue arises. Instances were observed where the new organization, while applying for provisional registration, they should have applied for provisional registration for 3 years, but selected the 5-year code. And because of no inquiry has been made and the application registration was granted just on the submitting of application, the 5-year registration have been granted to them. Though they were not a 12-year registered organization, and they wanted to apply for provisional registration. So, what in such cases, what the organization should do?
Here again, it is a mistake. It is a mistake, but since granting 12-year registration, AB registration is a discretionary power of the commissioner, and they have 5-year registration, so they can continue with their existing certificate. They need not surrender it, but they should write to the commissioner that this is what has happened, and are they required to surrender and apply it fresh? So that communication they should have in possession, because it is a mistake, and they should not leave it before October. They should take that precautionary step. So don't surrender your 12-year registration certificate because it has been issued by the commissioner. The commissioner has a power to issue it even without inquiry and investigation. So therefore, it is a valid certificate issued by the commissioner, even though it is issued by mistake. But since it is a mistake, instead of putting up a 154 petition, a clarification should be sought regarding whether something needs to be done with this regard with this certificate, or they can continue with this certificate to the commissioner exemption. So this is what a practical solution we are suggesting. Suraj, you have thoughts on this?
Yeah, actually, we can also take another reports as well, because we were not eligible for getting this 5-year registration, and this 5-year registration we have just received by default and by mistake. So we can submit our 154 petition to the CIT exemption, stating the fact and asking them to convert this 5-year registration to 3-year registration, and then we can submit form number 10AB to regularize our registration to normal registration. That can be the another way, because the registration granted under a wrong notion, maybe from the department or maybe from the SSA side, on the wrong declaration, because the.
So these are the options. In any case, a communication with the CIT exemption should be made. The organization should accordingly take a call.
So far we are dealing with the relaxation given to existing organization which were approved and registered as on 31st March 21. Now the second relaxation has been given to the NGOs or organizations who have failed to convert their provisional registration to a regular registration. Okay, and this circular has classified their case into 3 different categories. First category, they are saying if the application is in form number 10AB has not been made so far and the time limit has expired. That means we were required to submit our application by 30th September 22, and we have not submitted the application even now. The second situation is they are saying if the application in form number 10AB has already been made, but beyond the specified time, suppose 30th September was the deadline, then we have submitted the application in October 22, and the order is yet to be passed. And the third case is they are taking up the case where application has been rejected only on the ground that the application have been furnished after the due date. Okay, so in the first case where no application has been made so far, then in that case the process is very simple. We have to just submit application in form number 10AB latest by 30th of September. Then application shall be considered and disposed of after hearing. And in such cases, even after this delay, no exit tax for delay in filing application form number 10AB. Now in second cases where we have already submitted our 10AB application, but after the due date, what's those organizations shall do, but order is yet to be passed. In such cases, the circular says the pending application in form number 10AB shall be treated as a valid application, though it has been filed belatedly, but as per the terms of this circular, that application becomes your regular application, and based upon that application only, the application shall be processed and registration shall be granted after hearing. And in the third case, where application has already been made and the rejection is there only due to furnishing the application after the due date. In those cases, the circular says we have to make a fresh application in form number 10AB within the extended time limit of 30th 9/23. In such cases, application shall be considered and disposed of after hearing. And in such cases also, once the application is considered and registration has been granted, there should be no exit tax. So the circular has thoroughly dealt upon with all the 3 situations that may be there for converting, missing the deadline for converting the provisional registration to regular registration. But by default, they have not included in this relaxation that missing the timeline for converting converting provisional approval under section 80G to a regular approval under section 80G. So that means for section 12AB and for section 1023C, this relaxation is there that we can submit now, or we can our already filed application shall be considered as application. But for 80G, they have not included section 80G regularization under this circular. Though for 5-year registration, they have included 80G. But for converting provisional to regular registration, 80G has not been included. Now, this circular has also given the clarification on the date of effectiveness of the provisional approval or registration. As we all know, that the effectiveness of the provisional registration, that means first time when we are applying for the registration or approval, either under section 1023C or 12AB or 80G, the provision says the application for a provisional registration and approval is required to be made at least 1 month prior to the commencement of the previous year relevant to the assessment year, for which the registration and approval is granted. is sought for. That means if we want to take the benefit of registration for the financial year 23-24, then we have to submit our application 1 month prior to the commencement of the previous year. That means by 20th of February 23, we should have submitted our application. So always there, technically as per the law, we have to submit our application 1 month, 1 year before than the previous year from which we wanted to have this provisional registration effectiveness. But at the same time, the existing provisions defining the time limit of granting the provisional registration, they are saying such registration and approval shall be effective from the assessment year immediately following the previous year in which the application is made. So though some of the provisions for making application prescribing the timeline of 1 month prior to the commencement of the previous year, but the other provisions subsections says that registration approval granted shall be effective for the financial year in which the application is made. So this anomaly has been brought to the notice in this circular, and it has been clarified that the provisional registration approval shall be effective from the assessment year relevant to the previous year in which application is made, subject to the provision of converting the same to the normal registration. So now there is no compulsion of filing application 1 month prior to the commencement of the previous year. Your application shall be your approval shall be effective from the previous year in which the application has been made. So now the issue arises, Manojji, whether this circular, which is clarificatory in nature, shall have its force for previous approval granted?
Previous approval granted for ATG, you are
ATG, because in some of the cases, suppose we have submitted our ATG application in February 23 or January 23, and the approval and ATG approval has been granted from 7/4/23. That means after the end of the financial year in which the application was made. So whether those cases where approval has already been granted, but not in terms of this circular, whether they can go for 154 petition?
Because this is a clarificatory circular, I think they are eligible for the benefits from the year in which they were granted, because this is an issue we have been debating. So what is your view, Sureshji?
I also hold the same view, because whenever a clarificatory nature circular is coming, that means this is deemed to be applying to all the just deemed to clarify the situation of the provision of the Act, and it is not, it should not have a prospective implication. So I think whenever we feel we should have ATG from the back years as well, I think we can take recourse of this circular and can oppose the CIT exemption for necessary modification. Now, we should now deal upon what shall be the implication for not giving this relaxation benefit for the ATG approvals. So, the circular has extended the date for submitting application in form number 10AB to convert provisional registration 12AB and 1023C, where the due date has been expired, but no such extension has been given for the provisional approval under section ATG. Now, provisional approval under section ATG was granted for a period of 3 years, and with the condition that the approval shall be regularized within 6 months of the commencement of charitable activity or 6 months prior to the expiry of provisional approval, whichever is earlier. So that means the ATG approval was granted basically for 3 years, and one of the conditions was that we should apply for regularizing this approval to a normal registration within 6 months of the commencement of the activity, and latest by 6 months prior to the expiry of provisional registration. Again, no implication has been provided in the Act if the delay is made in making such application. Though the implication for delay application in 12AB and for approval in section 10.10.3 has been provided that delay submitting of this form number to convert provisional to regular registration shall be included as one of the specified condition, resulting into a cancellation of registration. But there is no such specified condition for delay in submitting ATG. So what then has the issue to be examined in such cases? Donation already received up to the due date of submitting the return, or donation received subsequently, whether those donations shall be subject to the benefit of ATG or not. As per the, if we're going through the circular so far, we don't find any circular in this regard under the 1961 Act. But if we go to the 1922 Act, then we find board circular number 28 dated 21st September 61, which provides that certificate granted under section 15B. 15B used to be deal with the donation like ATG. There they are saying any order cancelling a certificate under Section 15B can have effect only after the date of order. Therefore, donations which were paid before the date should not be denied, and rebate admissible under Section 15B should be granted. But that means the circular gives a direction which we can refer that the benefit of withdrawal should be from the date of cancellation or date of refusal and not from the date your failure to submit the application. But again, this will be a subject matter of debate because at that time, this concept of renewal was not there. The concept of refusal was not there. Refusal to consider application. So in this light, Manoj, we should discuss the implication of donation received in each of the following cases. And the first case is we have submitted timely application for converting provisional registration, but that application has not been considered on 28th February 23. So what shall be the impact on the donation received during the financial year 20?
Yes.
Yeah, Manoj.
Yes. What is the context?
The first case is, context was when we have submitted our application in time, but the ETG approval was not granted, the renewal was not granted. So let's say on 28th February 23. So what shall be the implication of donation already received?
If the renewal was not granted, but if you are eligible,
granted maybe because of their religious expenses were more than 5% on those regions.
If there was a violation, then I think what view is coming out at your end?
Yeah, actually the date of cancellation is 28th February 23. So I think the donation received prior to 28th February 23 should be eligible for ETG, and only donation received subsequent to 28th February 23 should be outside the purview of ETG.
And here, as you were discussing about the circular, let me add one thing. That from circular we get a view that ETG is subject to cancellation, and unless it is cancelled, whether a provisional or a regular registration should be treated as valid. But at the same time, we should not forget that if an organization after 6 months is has defaulted in not applying for regular registration, then the CIT would have the power to initiate cancellation proceeding from the date on which 6 months expired. So it is not a free run that an organization can have by defaulting 3 years ETG registration. Just to put that in context.
The second situation arises, Manoj, that we have submitted application in Form 10B delayed. In the first case, the application was filed in within time, and it was refused on some other ground. In the second case, we have submitted our application delayed, and rejection was made only on that ground only. In such cases, whether the ETG donation shall be from the date of rejection or from the date of 1st October 23 or 22 or
that again is a tickless issue. So what is the view coming out in your mind?
Actually, this is very controversial. This may be very controversial issues because in this case, your application has been they may not be surrendering your cancellation approval. They have just refused to entertain your application, and the word cancellation may not have been used. We have to see the orders what they are making, and if they are saying using the word refusal, that tantamount to cancellation only. So if we go by that circular, then after the date of cancellation order should be there. But if we take a conservative view, then I think from 1st October 2022, whatever donations they have received, or after the due date of submitting the return, there should be donation may not be eligible for ATG.
In my opinion, it would be a reasonable analysis to take it from 1st October 22 rather than taking the circular.
And in the third case, the NGO has not even applied as of now, though the date expired on 30th September 22, and they have not applied now, even now. In those cases, what shall be the implication for ETG benefit?
No, they can apply, try to apply. In these circumstances, what you think could be a possibility?
I think in such cases, if they don't want to regularize their ATG approval, then they should get benefit only up to 30th September 22. Or if they want to regularize their ATG approval, then they should file for provisional registration, or they should apply for with a convention of delay. But ATG benefit will not be there after 1st October 22, as we have discussed for case B, once the registration has been approval has been re-granted to them.
No, unless that condonation is accepted.
Okay, accepted.
That is a discretion of the CIT. Unless the condonation is accepted, 30th September 2022 should be the cutoff date.
So the last issue arises, which we have discussed in part, if the organization obtained provisional approval section ATG, but application for conversion to regular approval could not be made in time. And we all know from 1st October, they will not be in a position to make it to regularize because they were an existing organization claiming benefit of 10B. So they have to regularize within September only. So what they should do? They should be out from the system of ATG approval, or
this conversion could not be made because it is not specifically mentioned. We believe that it could not have been the intent. What is the status? Is the utility allowing such application, or it is not accepting?
No. The organization, we are not knowing the time limit. They have failed to submit their application. Circular doesn't allow them to regularize. Okay. Yes. Now they are in a fix. If they don't get this ATG approval regularized, even as a new case, they cannot apply from 1st October, because in those cases they will be existing organization claiming benefit in section 10 or 1023 or 11, 12 benefit. Yes, so they have to regularize before October. So what's
in the first part of our presentation, we discussed that both for 12AB registered and ATG registered organization, this bar of having availed benefit under section 11 in the past will be a disqualification, and this disqualification is not there up to 30th September. Therefore, if they want, they should immediately apply for provisional, and in the due course they should get it regularized. That is the only option.
Because they're applying for the provisional, at least from this financial year, they will get. Only for them, the 6 months shall be at risk, October 22 to March 23. Yes. Because of and if they want to avail also for that period, because of they have taken a huge amount of donation, I think then they have to submit their application form number 10A and approach CBDT for condonation of this delay.
And that is what I was asking. Is the 10AB is accepted in such cases in the utility?
In case it is not even accepted, they should make a formal representation to the CBDT asking for the condonation of delay and allowing them to submit their application.
Yeah.
So now we are to the question answer session. Tarunji, you can.
Sir, a question from Anant. Sir, if an NGO gets provisional approval by filing Form 10A in 2021 and till date they have not submitted Form 10AB, what will be the status and what should be the course of action be taken now?
As we discussed earlier, they should surrender that provisional registration, even if it is in the period of default, and they should apply for the 5-year registration within 30th September.
Tarun, it is a case where the organization were already registered in section 12A, but they obtained provisional registration. They are eligible for 5-year registration, but they have obtained 5 provisional registration. That is the case, or?
So no, it is just the case that they have obtained the provisional registration and then they have not submitted the application for conversion of provisional registration.
Then circular applies. They can appeal. They can submit now 10AB form, and they can hearing shall be granted.
30th September they can convert their provisional to the regular registration.
Only for the benefit of others, we are talking about organizations which did not have 12-year registration earlier.
Yeah.
Sir, what will be the implication if we just modify the facts and that organization was registered prior to 1st of April 21 as a normal, and it was required to re-register, but got the provisional registration. And now it has not submitted any application for the conversion of provisional registration.
Yeah, so that is where we said in such cases, we have already tried and we were successfully made attempts. The existing provisional registration certificate may be surrendered and application before 30th of September should be made, 1st October should be made, so for 5 years.
So a question is coming from many people, how to surrender. I think there is a functionality at the portal itself to surrender the provisional registration.
There are two utility. One is surrender and one is rectification. Okay. Yes. So by typing the surrender tab, they can surrender, and they have to also give the reason why they want to surrender. And that the reason they have to mention that they have obtained the provisional registration by in a wrong notion, or by they should give the reason, and then they should surrender. And so they should get the printout of, and they should get the take the printout of that application being surrendered and keep in their file.
So you don't need to submit a manual application with the Commissioner of Income Tax or anywhere else, or to the CPC. You just need to use the online functionality available at the e-filing portal. From there, you can surrender your provisional registration and get that regular re-registration. Sir, please cover cases wherein provisional registration was taken by trust. Subsequent application was made within the time for permanent registration. However, the application was rejected before the 31st March 23.
And the reason was?
Application was rejected.
The reason was? And the reason for rejection was not the
reason
timeline.
Cannot be the, because application was filed within the time. The reason could be like the non-producing books of accounts or any reason.
In our opinion, even in such cases, because there is no existing registration and they were eligible under the circular on 31st March 2021, they should apply under circular. If the CIT, because these are automatic renewal without any verification. So even if they were subjected to certain verifications which were rejected and all those things, they are events which were not applicable to registrations which were under automatic category. So that should not take away their right of automatic renewal, and they should apply under taking benefit of this circular. Since their provisional does not exist, so there is no question of renewing it, surrendering it. So they should straight away apply for it. So this is what is coming to my mind. Sureshji?
But this case, the challenge can be from the portal. The portal may not allow you to submit. And again, when the CIT, after examination, found to be an entity not eligible for registration. So this might be some challenge. But if this is a case of a pure provisional registration, not from the existing organization, a pure provisional registration submitted in time and the registration was not granted, in those cases, the circular will not come into rescue. You have to file to the tribunal, executing with the grounds of rejection. That is what the point of law is, that by mistake they applied for provisional and then by mistake they applied for regularization. They did have the right to continue the old registration for continuation for 5 years without any verification. So therefore they should try at the portal. Most probably the portal will allow. If the portal does not allow, then they should take up the matter with the CIT proactively, so that at least there will be some legal recourse available, because they have a sword hanging of 115 TD. Yeah. See, even in future, they are able to get a registration restored. Still 115 TD will apply if this old registration is not continued. So therefore, they should take these two steps.
Sir, there were multiple questions on the similar ground. If I summarize what we just discussed, if there was any existing organization prior to 1st of April 21, it was valid, it had valid registration, and by mistake applied for the provisional registration, then it can surrender and apply for the re-registration. But if it was a new organization which is applying for the first time after the 1st of April 21, it had applied for the provisional registration, but either it had failed to convert the provisional registration into the regular, or it has filed application after the 6 months time and its application is rejected only on the ground of that it was filed beyond the time limit, then it is eligible to re-register. If it was rejected on some other grounds, then it cannot apply.
Then they have to go to the legal recourse of appeal to the tribunal.
They can go to the appellate courts to the tribunal. Or
Circular 6 will not be applicable to them.
Sir, if the trust avail benefit of this circular, what will be the date of effective registration under section 12AB, whether 1st of April 21 or 1st of April 23?
Here, this would be get a 5-year registration from 1/4/22 only, because your last registration was valid up to 31st March 21. So from the financial year 21-22, you will get just like the other organization used to get before. Okay. The only thing, once you apply for 10A, then the portal, the two options will come. You are applying from 22-23 or from 24-25. So you have to very sure you take 22-23, because you are an existing organization and you are eligible for 5-year registration from 22-23 itself. So just choose the correct tab and then you apply.
Sir, we are a new Section 8 company. They applied for the 12A and ATG on the 3rd of September 22. But the email the income tax department had sent them asking for the provisional registration certificate, it somehow went into the spam of the email box and they could not apply it. And the application was rejected. What will be the recourse now?
The application for provisional or the regularization.
So I am assuming it was for the conversion, because the department had asked for the copy of the provisional registration certificate.
So if it is a conversion registration in the normal course of proceeding has been rejected, then a rejection order normally has to be taken to the legal recourse, because what are the grounds? Normally, if the rejection has been made on technical grounds such as non-production of books of account or a particular document, the CIT can also take up the registration again if once those conditions are fulfilled. But in all other cases, the CIT does not have the power to reconsider its refusal order. It has to go to the tribunal. So we assume that in this case, it is a technical problem regarding non-receipt of information, inability. So they can take up this matter with the CIT and they may apply again, but it has to be taken bilaterally with the CIT, and the CIT has to invoke its power to process their application. I don't think it will be possible on the portal.
Tarun, in such cases, they see the order. If the only reason is because of the timeline, due date of the timeline, then they should take records of this circular and they can submit again. Okay. But if the reason is other than the timeline, then what Manojji said is applicable.
They have to opt for appellate route.
Yeah.
Sir, if a trust was earlier having 12-way registration, but later stopped all activities and started offering all income to tax, but after April 21, it got itself registered, what is the way forward?
If after April 21, I presume it has taken provisional registration and got it regularized into a normal registration, I don't think this 115 TD will get invoked. And since they have a valid 12-way registration, they can continue to enjoy the benefits if they have the valid 12-way registration. Sureshji, this is a different.
The query is not very clear. Had it been the case that they were having 12-way registration before 31st March 21, but they were not claiming in their return. Okay. And after 31st March, they have applied for provisional. The query has to be very, very clear. If they were not an existing organization as on 31st March 21, existing means as a registered registration with income tax, then the provisional registration and getting it regularized will be sufficient. There is no 115 TD application.
Yes, we are answering this question under the assumption that on 31st March 21, they did not have 12-way registration. They were being assessed under section 57 without having any registration.
Yeah.
In that case, they will not face any problem. Otherwise, they have to take recourse under this circular.
Sir, another very, very important question. Sir, a trust was registered prior to 1st of April 21, but it failed to get the re-registration. Now, getting the benefit of this circular, it wants to get re-registration itself by the 30th of September 23. But because it was not registered for the financial year 21-22 and 22-23, it had filed its income tax return as an AOP and not as a registered trust. Now, how the returns of that past 2 years will be rectified and what will be the recourse available?
There are two issues. Registration issue is in the domain of the Commissioner of Income Tax, and the assessment issues are different. But now the issue here is that the complication is that had there been an order once after getting the benefit of the circular, a new registration certificate for all existing order, they could have applied for under 154 for rectification of the order. But even now, if there is an order, because against a written, your self-declared return, you cannot file on 154. But if there is an order under 143(1) or anything, they can move a 154 petition saying that due to the non-availability of 12-baby registration, these benefits were not claimed. It may kindly be allowed, but it will be extremely difficult because of the conditions of Section 12A, the audit condition, the return under ITR 7 condition. So it is a complex issue whether they can get the benefit under provision to Section 12(2), where even if they are not complying with 12A, that is the only avenue under which they can try for assessment prior to, where they can say that even if you were not complying with the conditions of Section 11 and Section 12A, but we are eligible for retrospective assessment benefit under Section 12A2 provisos. So these are few legal avenues they can explore. It is quite complex. Sureshji?
Just to add here, Manojji, they should have to recognize their approval registration, is no doubt about it, because otherwise they will be subject to 150 because of non-application, because they were an existing organization as on 31st March 21. So by any means, they have to apply and get it recognized. Now, the only issue is how to recognize their past assessments, or if the past returns, if the no assessment has been made. And in past assessments, if they have tax implication is huge, and they have paid huge tax implication, because if they are submitted, there are cases where the organization have submitted in those years also ITR 7. And the intimation was received disallowing the application money because of the non-registration. In those cases, we are filing 154 petition. That the benefit of registration was not there, so the registration benefit was not granted. Now I have received the registration. Now that too from 20 to 23, so my order should be revised. Intimation should be revised. But in such case of ITR 5, I don't understand. We have to see how this ITR 5 intimation has come. Okay, and based upon that, they have to take a legal recourse.
Yes, and even under Section 12A2, all taxes which have already been paid cannot be refunded. So that is another challenge. So new demand cannot be raised. So you may not be subjected to new demand, or if the demands are pending, then maybe you may try to take benefit of Section 12A, the provision to Section 12A2. But you have already paid taxes, then I think it is unlikely that you will be able to claim those taxes back.
There could be another question in my mind linked to it, since returns could be, there could be possibility that under 154 that return can be rectified or whatever can be done. But similarly, they have provided this relief for the ATG as well. Now ATG will also be effective from the 1st of April 21. Now can they pass on the past year benefit to the donors or for the CSR purposes or other purposes?
I think
if
they have not claimed benefit of Section 11 in those 2 years, the ATG should not be applicable for those 2 years, because the condition of ATG, 5-6 condition in the ATG section itself, that for that year your income should be under Section 11-12 exempt. But in these cases, they are not claiming exemption in those sections. So technically, though they are receiving the ATG certificate from back years, but they should not be able to pass on because they know they have not claimed. It is not that after assessment they are getting it.
Yes, and in any case, they were not entitled to take donation under ATG without applying for the renewal after that. So you cannot just keep quiet and keep on taking ATG donations after 1st April 2021.
And sir, what will be the possibility since financial year 20 to 23 return is still yet to be filed, and that can be filed in ITR 7 if they get the registration certificate
Yes,
from the
yes,
Yeah,
yes,
that is always
that year they can take the
yes,
benefits.
yes.
Sir, a trust applied for the re-registration in September 21 and the re-registration certificate was granted, but the trust was not aware that it is re-registered and it failed to submit its income tax return. Now, what will be the course of action in this case, since the filing of ITR is one of the conditions to claim the exemption benefit?
Most likely, it will be subjected to the failure of filing return, because it is unlikely that it can correct that mistake. So, Sureshji, what could be a possible solution?
Even if 139(4) time limit has gone, that means
Yes,
they
sir.
themselves they cannot file return or updated return. So only in 148 proceedings this can be regularized. Okay. And on the other way, if the NGO thinks they shall be subject to the huge tax liability if this 12-way benefit is not granted to them, because 13, 10, 11 was not there in that year, because they have a huge capital expenditure and they want to accumulate for 15%. In those cases, I see the situations where giving some reasons why they could not submit the return, because non-receiving of registration certificate is not a reason for non-submission return. They have to submit ITR 5. So if they find out some reasonable basis of not submitting the return, they can approach CBDT for continuation of this delay, and they can allow in some cases. In our cases, the CBDT has given the continuation, but the reasons has to be very, very firm.
Sir, where a trust has got provisional registration and started to receive donations and also making application without applying for conversion, can exemption under section 11 and 12 be valid for 3 years period?
Again, repeat.
Sir, a trust was provisionally registered. It started taking donations and also started applying its income, but it had not converted within the time limit. And whether it can continue claiming the benefit for a period of 3 years without getting the conversion to the regular registration.
We are assuming that it is a new trust which was not registered prior to March 2021. And as we have said that we cannot take a liberal interpretation of that 6-month limit. So when those 6 months has elapsed, so from that day, the CIT would have the power to cancel their registration. But because this registration is not an assessment issue, it is an issue in the domain of the CIT. So technically, the 6 months is the limit beyond which they would not be eligible, but subject to action by the Commissioner of Income Tax. So, Suresh,
why not they taking recourse of this circular and applying now?
Yes, no, it was not registered. The recourse of the circular for provisional registration.
No, they were provisional registered. No? They were provisional.
Yes. They can always.
They can get conversion by
30th.
Yes.
They have the recourse of this circular.
Yes, that we can. They can always do. Yes.
Sir, application was filed for conversion of provisional registration to regular registration within 6 months, but no order was received till 31st March 23. What is the status of exemption for assessment year 23-24 if no order was passed until 31st March 23?
Sureshji?
I think their provisional registration is effective only not up to March 23. They have to see up to what year the provisional registration was valid for the 3 years. If that 3 years expires after March 23, they should not be worried, because they have given the timely application is only pending before the CIT exemption. Okay. But if their expiry period also completes on March 23, or then only they have to then apply for renewal. But I don't think any of the provisional registration is expiring on March 23, because the scheme started in April 21. The first provisional registration will apply after 3 years. So March 23 cannot be the date for expiry of provisional registration.
Sir, NGO has renewed its 5 years registration within the time limit and received order in Form 10 AC. However, no separate ATG order has been received. It was existing earlier. Should it apply separately again now? How to check ATG exemption availability?
If they have not applied or they have not, they just check the portal, And if they're not applied, they should apply now, because this circular allows them to apply, and they will get all the 5-year registration. And in such cases, they have to also come out how they have submitted the 10BD application form last year. And okay, so if it is not there, they can revise it through this circular. That is very clear.
Yes. There were 2 separate applications were supposed to be filed, one for 12A and one for ATG. If you have not filed a separate application, then you can apply now by 30th of September 20. Sir, what will be your answer in case an existing trust was existing from 2010? Provisional registration has been obtained in May 31st, 2021. Should we convert this into permanent registration by filing Form 10AB now?
If they have not done, yes.
It is squarely within the circular.
Yes. Sir, if any educational trust earlier applied for approval with Form 56, which was earlier for the 1023C, but 1023-6 BIA they had applied for, but as per the final order received from department, that most of their grants are received by the education trust from government, it will be assessed under 1023C III-AB. So as for the benefit of III-AB, there is no approval required. What implications are there under the recent amendments?
The III-AB is a special section under which any income, the word has been used that any income of that organization, because III-AB substantially funded by government, that all the income and the surplus are considered as a part of the consolidated fund of India. So such institutions are not subject to tax. But as we told, that since this organization probably was not substantially funded by government earlier and became substantially funded, or by mistake it has obtained 1023C registration. Our view is that because it has by mistake taken the registration, even if it is not claiming the benefit in future, it should take the renewal to avoid section 115 TD. Sureshji?
Yeah, the same position we have taken in our PPT also, because of the 5 crore and 1 crore. So if you are an existing approved organization under section 1023C as on 31st March 21, and technically if you are not applying for re-approval for 5 years, so technically it falls under 150 TD. So just to avoid that technical implication, you can apply for 5 years and then approach the CIT exemption that we want to surrender because of these reasons.
Yes, and in return, don't claim the exemption. You claim exemption under 3AB only.
Sir, if a trust, continuing the same example, if a trust is in the approval category of section 1023C and their turnover is below the limit of 5 crore and they are claiming exemption under that particular section, whether the audit report will be required to file, since they are having approval, but they are not claiming exemption under that particular section.
Once they are claiming this 1023C AC and AD below 5 crore, they will not be subject to the audit provisions. So even if they have registration, if they are claiming benefit otherwise for that year, I don't think they will be required to file the audit report. Sureshji, this again is a complex question.
As of now, I hold the same view. But now we have to see the requirement of audit, whether it is on the basis of just having approval or just on the basis of taking benefit of approval. So we have to see the actual, in the literal sense, what is the requirement of 10BB. Okay. So if it is not on the basis of only approval granted, then I think there is no need for audit.
Sir, a trust was earlier registered under section 1023C. Prior to 1st of April 21, but while applying for the re-registration, it had applied for the 12A. Now, whether such regime can be changed or cancelled and get again re-registered into 1023C?
That there is a Karnataka High Court order which had directed the CIT on the other way around, because for CSR registration, the requirement was 12A registration, and an organization by mistake took 1023C registration and could not get the benefits of CSR donations under section 12AB because So this there was a direction from the Karnataka High Court to switch the registration. But in such cases, because they have taken a regular registration, they should see whether they can surrender this registration on the portal. Otherwise, they have to take it up with the CIT directly. I think it will be difficult to do it under the existing utility if it is a 5-year complete registration. So, but taking those judicial precedents, they can take it up with the CIT.
Yeah, because under the Act, Income Tax Act and rules, there is no provision for surrender and apply again or shifting to one regime to another regime.
Yeah.
Okay, so we have to be engaged with the CIT exemption on this one issue.
Sir, a trust was provisional registered. It had applied for conversion of provisional to the regular registration, but the Form 10AB application was rejected ex parte by the CIT exemption for non-service of notice for hearing. Now the department has agreed to serve the notice and advised to apply for Form 10AB again, but the portal is not allowing them to do so. So what will be the recourse available to them?
Because you have to engage with the CIT only, because if you are applying on the basis of the direction of the CIT, I think this matter has to be taken up with the jurisdiction CIT only.
Because under the law, CIT exemption reject and cannot ask you to file again. Okay. So if we want to take the recourse of this circular, then we have to see whether our application was submitted belatedly or within time. It was within time and then ex parte order. I think they should engage with the CIT exemption. At the same time, they should also file appeal with the ITT tribunal. Otherwise, the time limit is also there to file the appeal.
For a small trust having a surplus less than the taxable limit of 5 lakhs per annum, can they avoid this entire registration and the cumbersome process we are listening about?
They have not yet registered?
They are not registered. They want to just do the basic calculation of under 5 heads of income.
And register or not? They are just thinking. They can act as a non-registered organization, and their taxation certificate with the normal heads of income. So they have to just recompute their tax liability. And based upon, and they will not be able to raise funds because the ATG will not be there. For CSR, we require 12 baby registrations. So for FCRA, so if they don't want raise funds from the public and they are comfortable in paying tax as per the normal heads of income, then they can take a call.
Sir, a trust had filed Form 10BD for the financial year 21-22 in time and issued the Form 10BE to all the donors. Now, this year, when they are filing for Form 10BD, it shows error that date of issuance of URN is invalid and the last date is 30th of June. And now they have noticed that the reason of this error could be because they have not converted their provisional registration to the regular registration. Now, can they do so conversion now and then file Form 10BD?
They have to convert now, and there will be some delay in filing 10BD, that they have to pay penalty for those delays. Suppose in getting regularized, maybe from 10th July they will get. And then they are
conversion relief is not available for Section 80G.
80G, then they're problem. 80G, they have to they have to go to CBDT and those things, because last year, though, even we filed today as a new case from this year only. So last year they will not get. So if they were an existing organization before, so they have to take with the CBDT only.
Sir, I think we have taken the registration related queries. I am just leaving the computation and other related queries. Otherwise, this session will go so long. Just last query on the registration. We have been registered since 2005 and got provisional registration on April 22 and got provisional certificate valid for 5 years. Please advise if we need to apply for the regular registration.
Actually, this should refer Circular 11 in August, issued in August 22. The provisional word is by mistake in the mention in the certificate. They have been granted 5-year registration already, so there is no need to apply again. And their provisional word should be read as not being there in the certificate. So there's no need for again for them.
They already have a proper 5-year registration. Initially, few certificates by mistake the word provisional was used. So if 5 assessment year is provided in the certificate and clause 1 is mentioned in the certificate, if those two things are there, then it is a valid certificate. And the CBDT has also issued a clarificatory circular, which Suresh ji is referring to. So therefore, they need not worry, but they just do a due diligence and check their certificate, and they need not do anything else.
So you can keep a copy of that circular with you, where it is mentioned that word provisional should be read as a final, right? So you can keep a copy of circular with the registration certificate. So I think we can conclude the session here. There were many queries, and this topic is so vast that queries are never ending on this topic. Even if we were just having a session on the registration topic, and there is so much to discuss about, and there are so many controversial issues which are unaddressed by this circular itself. I think for the other queries which are related to the computation, we'll be coming up a separate sessions on that topic. We are coming up with a 3-day course on the maintenance of books of accounts, filing of audit report in Form 10B and 10BB, which are revised. And there are so many complexities in those forms, and we'll be coming up with the filing of Form ITR 7. So there will be a 3-day session in the first week of August, because July will be the ITR season for you all, and the audit and season begins in the August itself. So we'll be coming with a 3-day course on that topic, and you can enroll for those courses at the Taxmann website. So thank you everyone for your patient listening. I think we'll conclude here. I'll also like to thank Manoj sir and Suresh sir. So they are so positive, and they always come up with such issues, and so much controversial issues are being always addressed for the benefit of NGOs and the participants. Thank you, sir.
Thank you. Thank you all.